So the police are now threatening to charge people with a criminal offence for what you might refer to as hurty words, or as they put it in this post here, unkind, derogatory comments on their social media posts. And I'm here in this video to tell you why, to some degree, that's just complete nonsense. Now, a huge caveat here, I generally support the police. I will criticise where I think they've done something wrong, but generally I support the police. They have a difficult job to do. They try to keep us all safe. We would be worse off without them, and we deserve a properly policed society and all the rest of it. So that caveat out of the way, this is not a dig at the police. This is just, if you like, a balanced overview of what this post means, what you should and shouldn't do, what you can and can't do, generally speaking, not legal advice. But let's take a look at this post, because I came across this and I thought this deserves some kind of comment here, because to some degree, I understand why they've put it on here. It's a bit like those signs saying, please don't insult our staff and things, which is perfectly fine. But at the same time, it comes along with a threat that you'll be prosecuted. And I think that is borderline abusive of the position. But that's just a general opinion overview of this thing here. But let's have a look at what it says. It says, we do not tolerate personal, unkind, or derogatory comments on our posts. Now let's break that apart. The personal bit, of course, you should take the personal bit out, because whoever's making the post is doing a job, and so don't make these things personal. But when it comes to unkind and derogatory comments, to some degree, you can make those comments, but I'll come back to that in a moment. It says our frontline officers and staff have different roles, ranging from emergency response to community engagement. Obviously, this is a focus on the community engagement with these posts here. They do not come to work to be abused. Social media is no exception. Now, I do generally agree with that. You know, you shouldn't abuse the staff that are making use of social media to put these posts out there. We use social media to offer reassurance that we are present, addressing problems that are an issue in your area, engaging with the community to build trust and confidence. We are taking action on comments. This is the bit that I do take issue with here. We are taking action on comments that are categorized as a crime. Strictly speaking, as it's written, that's perfectly fine. If they are categorized as a crime, then absolutely they should take action on them, and absolutely the people responsible for those comments that amount to a crime should be held responsible for them. But when you read this in context with the header and the bit at the bottom, that we do not tolerate unkind or derogatory comments, and then we'll take action on those categorized as a crime, you may be led to believe that making an unkind comment is a crime, which is not, which I'll come back to in a minute. And it says here, if you feel you can positively impact how we respond to your community posts, please do attend one of our beat surgeries. Now, as I said, I am supportive of the police. I would suggest you go along, you talk to the police, you work with the police, because everybody wants a safer, well, almost everybody wants a safer community. Obviously, those that end up in prison for really heinous things probably don't believe in a safe society, but by the by. But let's look at something else here. Just making unkind and derogatory comments by itself will not amount to a crime. Now, I'd like to talk to you about a case here, which was where Christian fundamentalists had agreed with the police that they were going to preach from the steps of a cathedral. A police officer on uniformed foot patrol received a complaint about the women's activities and went to investigate. No crowd had yet gathered, but he warned the women not to stop people. He returned later to find a crowd of more than 100 people had gathered. Some members of the crowd were shouting hostility. Fearing a breach of the peace, the police officer asked the women to stop preaching, and they refused to do so. And when they refused, he arrested all of them for willfully obstructing the police officer in the execution of his duty under Section 89 of the Police Act 1996. This lady was convicted, appealed to the Crown Court. The Crown Court upheld the conviction, and then it was appealed by way of case stated, which is where the facts of the case are stated to the Court of Appeal. This is what happened. This is a point of law. We'd like the Court of Appeal to decide, was this right? Should this have happened? And the Court of Appeal, of course, can uphold the conviction or can quash the conviction by allowing the appeal. Long story short, they allowed the appeal in this case. The issue was whether it was reasonable for the officer, in light of all of what happened, to arrest this lady, believing that she was about to cause a breach of the peace. Now, the important bit, and why it relates to this social media post here, is that talking about free speech, the judge said, regard had to be had to the fact that free speech includes not only the inoffensive, but the irritating, contentious, eccentric, heretical, and the unwelcome and the provocative, provided it did not tend to provoke violence. So long as what you've said doesn't actually provoke violence or will not tend to provoke violence, which is something I'll come back to in a moment, which is why some people have gone to prison for what they've said, but I'll come back to that in a minute. So long as it doesn't do that, it can be irritating, it can be contentious, it can be eccentric, it can be heretical, it can be provocative, and in another case, it can also cause offense. And that doesn't make it a crime. Free speech does encompass all of that. And says here, freedom only to speak inoffensively is not worth having. The world has seen too many examples of state control of unofficial ideas. A central purpose of the convention had not been set to close limits on any such assumed power. And so the court allowed this appeal and quashed the conviction. And then you might wonder why certain people are indeed sent to prison for lengthy custodial sentences for what appears on the face of it just to be shouting at police. Such as one example here of Stephen Mallon, who joined in the recent disorder, and he was struck in the leg by the officer's baton because they said he was constantly in the face of officers, gesticulating and shouting towards the police. But this was during the overall civil disorder, riots. And so the reason for that is he was charged with violent disorder. Whereas you'll remember the chap that threw things at Nigel Farage, he was only charged, I say only, but only charged with Section 4 of the Public Order Act. So he was by himself. The others, there were several people involved. And violent disorder requires at least 3 people, 3 or more persons present to use or threaten unlawful violence, and then that can be charged as violent disorder. A riot requires 12. Standard public order, Section 4, can just be that individual person. But then when you look at the sentencing guidelines for each of these cases, we look at violent disorder, a maximum of 5 years, riot is 10 years. But even if you look at the lowest category of culpability and harm, so if we look at a 3C case here, which is the lowest of the seriousness, it is still up to a year's custody as a range. And the starting point is 26 weeks custody, all the way obviously up to the maximum. When you look at straightforward threatening behaviour, fear or provocation of violence, which is a Section 4 offence, and even if we look here at the highest, which could be here missiles thrown, so in the case of attacking Nigel Farage here, so missiles thrown, so whatever it might be is thrown. And if we look here, there may have been fear of violence caused to multiple persons because there was something being thrown. So even if that was a category 1A, even then, the starting point is a high-level community order. All that means is the judge is going to start at the point at not necessarily sending the person to prison, and then look at all the facts and the circumstances, and goes up or down with mitigating or aggravating circumstances, factors, and etc., and previous history. Does it get a little bit worse? Does it get a little bit better for the defendant? And in this case, it went sort of up a bit to a 6-week custodial sentence, but suspended for 12 months, so didn't go to prison. Whereas we flip back to this chap here, Stephen Mallon, he was sentenced to 26 months in prison, and some of the others who were doing vaguely similar things, but because it was all part of a group of violent disorder, they have all received fairly serious custodial sentences, which is why on the face of it, it might appear to be a 2-tier system. But because this other guy throwing something at Nigel Farage was effectively acting by himself, and violent disorder would require 3 people, so he was just charged with public order. So the real question there, if you have a question as to why there is a 2-tier between what these people have been sentenced with, it should be on the sentencing guidelines. But those are not created by the judge. And so for many people in the comments saying it is the judge's fault, well, respectfully, it isn't. It isn't the judge's fault. The judges are sentencing based on the sentencing guidelines, which is based on the offence being charged with, which is set in statute what they can and cannot be charged with. So one person by themselves cannot be charged with rioting and cannot be charged with violent disorder. But coming back to the social media post, I do think it is a bit of a stretch to be threatening people with being charged with a crime just for posting something unkind. Now, again, coming back to my caveat, I don't condone posting unkind things towards the police, but we do have the freedom of expression. So, as the judge said in this case, so if you only have the freedom to speak so long as it doesn't offend anybody, that is a freedom not worth having, according to the judge in this case. And so ironically, one of the reasons that I'm doing this video now is in the hopes that it prevents people posting unkind things to the police because of the Streisand effect that typically when someone tries to shut something down, it usually gets more and more out of control. That's not me encouraging it, by the way. That's just to say that that's what sometimes happens. When someone tries to suppress something in the news, it typically gets more attention than it would have got had they not tried to suppress it. So ironically, when a request is made to not be unkind, very often people are more unkind. Again, I'm not encouraging that. I don't encourage that. I don't encourage negative attitudes towards the police. This is an awareness thing. But this is also if people feel like they are being silenced. It is only if your words and actions cross a threshold that they become grossly offensive to the point they are unacceptable in a civil society, or worse still, that they encourage or incite actual violence. And so in a roundabout way, the government's comment on this, think before you post, was somewhat accurate. I just think that it's better that people understand the law, and that's why, hopefully, I give you the raw, blunt, honest analysis of what the law says. If you like that as an alternative from mainstream media, please do subscribe to my channel. Thank you for watching, and I'll see you next time.